Hi everyone, I am KAVYA, Assistant Professor of B.Sc from KSR Arts and Science College for Women, Tiruchengodu. Today we are going to see about the company law. The introduction for the company law. Company law governs formation, management, dissolution of companies. Main legislation is the Companies Act 2013. Ensures transparency, accountability and investor protection. Defines rights, duties and responsibilities of a company. Definition of a company. Section 2 of 20 of Companies Act 2013. A company incorporated under this act or previous company law. Artificial legal person created by law. Separate legal entity and separate legal identity from its members. Next is the characteristics of a company. The characteristics of a company are listed here, that is membership, incorporated association, separate legal existence, perpetual succession, common law, common seal, artificial person, limited liability, share transfer, maintenance of accounts book, audit of accounts. Next is company versus partnership. That is company governed by Companies Act 2013. The partnership is governed by Partnership Act 1932. Next is company has a separate legal entity. Partnership doesn't have a separate legal entity. Next, the liability is limited in company, unlimited in partnership. Perpetual succession is only in company, not in partnership. Next is formation of a company. And the formation of a company is a legal process through which the business entity is created as a separate legal entity capable of owning assets, entering contracts and issuing or being issued. It involves several key steps: selecting the type of a company, private or a public or a one-person company, obtaining a digital signature certificate and a director identification number for a purposed directors, reserving the company name with the register of a company, drafting the memorandum of association and the articles of association, filing incorporation forms with the register of a company and receiving a certificate of incorporation. Once incorporated, the company becomes a legal entity distinct from its members with perpetual succession and limited liability. This process ensures legal recognition, accountability and protection for shareholders and stakeholders. Next is Memorandum of Association. The meaning is the Memorandum of Association is a foundational character of a company that defines name, location, objectives, liability of members, capital structure and intention of the subscribers to form a company. It sets the legal limits within which a company must operate and protects investors by ensuring the clarity of purpose. Next is classes of MOA. Classes of MOA may be name class, register office class, object class, liability class and capital class, association or subscription class. Next is prospectus. The meaning of prospectus is a formal document issued by a company to invite the public to subscribe for shares or debentures. It provides essential information such as business details, financial statements, risk management structure and terms of issue to help the investors make informed decisions. A prospectus promotes the transparency in fundraising and safeguards investors by imposing strict legal liabilities for misstatements or omissions. Together, the MOA and prospectus play a vital role in a company formation, public investment and corporate governance. Next is contents of prospectus. The contents of prospectus are defined as company's financial information, business descriptions, risk factor, management and board details, capital structure, term of issue, auditor's report, declaration and certifications. Next is Unit 3. Unit 3 is company meetings and types. Company meetings are the formal gatherings where members or directors discuss and decide on important business matters and resolutions or the official decision made during such meetings. That is, meeting allow the members and directors to make key decisions, resolution record and formalize those decisions, essential for transparency and lawful governance. Next is types of company meeting. The company meetings are divided into 3 types: shareholders meeting, directors meeting, special meeting. Shareholders meetings are statutory meeting, annual general meeting and extraordinary general meeting. Directors meetings are board meeting and committee meeting. Special meetings are class meeting and creditors meeting. Next is resolution and types. A resolution is a formal decision passed by the members or the directors of a company during the meeting. It represents a collective approval of a group on a particular matter and becomes legally binding once it is adopted and recorded in a company's minutes. Types of resolution: ordinary resolution and special resolution. And the qualification of the auditors. A person is qualified to be appointed as an auditor of a company if they are a chartered accountant holding a valid certificate of practice. In case of a firm, a majority of partners must be practicing CAs, and only such partners can act and sign as auditors. The auditors must possess the required knowledge of accounting, auditing standards, and legal compliance to perform an independent examination of a company's financial statements. The disqualification of auditors: or a person cannot be appointed as an auditor if they fall under any of the following categories, that are: they are not a chartered accountant, they are an officer or an employee of a company, they are a partner or a employee of an officer or employee of a company. They hold securities or invest in the companies or its subsidiaries holding companies above the prescribed limit. They are indebted to company or its subsidiaries or holding company above the prescribed amount. They have guaranteed debits of company beyond the allowed limit. They have business relationships with the company that could affect the independence. They have been convicted of fraud and 10 years have not passed since convictions. They are already the auditor for more than allowed number of companies under law. These are the disqualifications of the auditors. Next is appointment of the auditor. The appointment of the auditors can be appointed at first annual general meeting of a company, subsequent annual general meeting for a term not exceeding 5 years, that is in a public company. Private companies may appoint the directors in the board meeting, can be appointed by the company members. The modes of appointment are by members at annual general meeting is most common, and by board of the directors in private companies, by tribunal or a court in cases of vacancy, fraud or mismanagement. Thank you. And thank you for giving me this opportunity.